So the webinar today is from First Community Trust. As our mission at DUPACO is to improve our members' financial position, we've partnered with First Community Trust to be able to offer and provide our members a full line of trust, investment, retirement, and wealth management services. Presenting today will be Chip Murray, and then Jim Little is also joined with First Community Trust, and he will be answering the questions throughout the presentation. So let me present Chip, and he will be doing the presentation today.
Thank you, Michelle, and we appreciate the opportunity to be making this presentation to DUPACO members. It's interesting, we've been working with DUPACO almost 20 years now, and as was mentioned, we have three main areas of our business. The first area we're going to cover this morning is estate planning. We talk about wills and trust, and today's discussion is going to focus almost entirely on that topic. The second area that we work in with DUPACO members is retirement and retirement planning. So if people are planning to retire or in retirement, we can help them as well. And what underlies everything we do is investment management. We help people manage their money, whether in retirement or whether they have excess funds that need some assistance. But as I mentioned, today we're going to talk almost exclusively about estate planning, wills, and trust. When I start this seminar, one of the first things I'd like to talk about is how are assets distributed nationwide? And this comes out of USA Today a couple of years ago, and it talks about across the country how is money disposed of when people die. And you can see that 64% go to children, 11% to relatives, 10% grandchildren, 8% charity. The left-hand side's fairly understandable. It gets more interesting on the right-hand side, 3% to friends, 2% to employees, and the last two, 1% to pets, and 1% to former spouses. And I always suggest at least the 1% to pets was intentional. Leona Helmsley owned a lot of hotels in New York City. When she died, she left $1 million for the care of her dog. So it would have been great to be her dog. One of the words that I hope I convey more than any other today is communication. What we are doing with estate planning is communicating our intentions as to what we want happened after we're no longer here. And generally, we're communicating or attempting to communicate to those people we care the most about. This slide indicates that it's not an easy topic to discuss. But as we go through here today, the communication theme will hopefully come through, and I'll refer back to the idea what we're trying to do with estate planning is to put a plan in place that can oftentimes avoid disagreements and conflict at the time of a person's death. Estate planning is not that difficult. It is simply a systematic way of taking care of a person's personal and financial affairs both while they're alive and then at the time of their death. And before we get to the end of this session, I think people will have a good idea whether a will or a trust might be the best route for them. We come across people often that do not have current estate plans, or many people do not even have a will or a trust. And the three reasons listed on this slide seem to capture most people. The first one's intimidation. I'm going to talk in a moment about the idea that you need to use an estate planning attorney when you are putting your estate plan together. And some people are intimidated about the idea of going and sitting down with an attorney. The second one is avoidance. I talk about my dad a lot in this seminar, and my dad would have fallen under the second one, avoidance. I truly think he believes that if he talked about the topic at all, something bad would have happened to him. And so some people just like to avoid the topic altogether. The last one's more common, and that's procrastination. And I think the majority of the people would fall under that category. People know they should have an estate plan in place, know they should update their will or trust, know they should have a will or trust, and they just put it off. Part of the goal of this seminar is to encourage people who need a will or need to have an updated will or trust, get it done before too awful long. When we start talking about estate planning, we oftentimes start with what are a person's total assets. And it's important to know what the assets are. And this helps also drive the decision as to whether a will or a trust is the right vehicle for people. So when people look at this slide and they see investments, retirement savings, real estate, they say, well, that's rather apparent. As I talk about this whole communication idea, you will see why it's important that we have this list, and even more important, that we keep the list current. Many times people today can provide a list or prepare a list, and as they age, sometimes people tend to forget about certain things, like annuities, like savings bonds. So having a list and keeping it current is extremely helpful to the overall process. I indicated that we were going to cover primarily wills and trusts today, but before we get to that, there are two other ways that we transfer assets to our heirs, and it's by law and by contract. By law is the first one. If you have a checking account, if you are married and you have a spouse and you have a checking account, generally speaking, that account's going to be titled joint with right of survivorship. My wife and I have everything titled joint with right of survivorship. What that means is when I die, everything goes to my wife by law. It doesn't make any difference what my will or trust says. And so that makes sense to people, but where we see this causing problems is after the first spouse passes away. We had a case where a gentleman worked at a local manufacturing plant and his wife had predeceased him. He had 5 children. He added his youngest daughter to his checking account because she lived nearby and could help him if there was an emergency or writing checks. The man died about 18 months later, and that checking account had grown to $18,000. Who got the money in that checking account? The daughter, joint with right of survivorship. The man's will said, divide everything 5 equal ways, and I really believe that's what he intended. And people say, well, surely they all got together. Surely they did not all get together. The youngest daughter said, I had done so much for Dad, he wanted me to have that money. So that's why it's important to understand how your accounts are titled. You also see accounts titled POD, pay on death, TOD, transfer on death. Those sorts of designations also will supersede a will or a trust. The next one that says by contract captures most everybody we visit with. If you have a 401k, if you have an IRA, if you have an annuity, if you have a life insurance policy, you have already filled out who the beneficiary designation is for that particular asset. And again, your will or trust does not have anything to do with where the money in those sorts of accounts would go. So if you have a 401k, an IRA, a life insurance policy, or an annuity, check to see what the beneficiary designation says. I always tell people, as a result of listening today, I would encourage them to do 2 things, and this is one of them. Check and see how your accounts are titled, check and see what your current beneficiary designations are, and make sure they match your wishes, and will also work in concert with your will or trust. And now, going forward, we will focus almost exclusively on wills or trust. The first thing we're going to talk about is a will. I mentioned earlier that you should work with a good estate planning attorney. I always suggest that if I hurt my knee playing racquetball, I wouldn't go to a dermatologist. I go to an orthopedic doctor. Attorneys also specialize. Attorneys specialize in real estate, corporate law, and some specialize in estate planning. It seems to me that we work really hard to accumulate our assets. We really care about the people that we want to take care of when we're no longer here. So working with a good attorney makes a lot of sense. First Community Trust has attorneys associated with our staff, but because we serve as executor, because we serve as trustees, it would be a conflict of interest for us to actually draft the document. So if I'm going to have a will, I will go to an estate planning attorney and he will draft the last will and testament of Chip Murray. In my will, I will name who is my executor, who is going to take over in the event of my death, who will handle my affairs when I die. And my will also have what are called dispositive provisions. How are all of my assets going to be disposed? Essentially, who gets what I have? It's going to say where everything should go at the time of my death. And so if I have a valid will, my will pass titled property according to my wishes. And where you see titled property, you can kind of think of financial assets, checking account, savings account. We'll assume my wife has now predeceased me, so my will becomes operative over all of my assets. So my will pass my checking account, my savings account, my stocks, my bonds. The house has a title. The financial assets will pass according to my will. My will may also pass personal property through a list that is referenced, and I'll come back to that in just a second. I think the last two bullets are important. It says what we're trying to do, back to that communication idea, is to help avoid disagreements among family members as to what's going to happen when someone passes away. The last line says it's a misconception that all family members will agree. I used to say at this seminar, it's amazing how the children fight when the second parent dies. And people kind of nod their heads and come in and visit with us, and they would say, what you said is absolutely correct, but my family's different. So I don't say that anymore. Now I say it's amazing when the second parent dies, how the in-laws can cause all these problems. And everybody can get on board with that one. You know, when my dad died, there was 4 kids. 4 kids were married. You have 8 people, 8 personalities, and people say and do and act in ways they otherwise don't say and do and act under times of grief and times of stress. And so that's what we're trying to do, is to reduce that stress by having a good communication plan in place. And that brings me back to the second bullet, because it seems as though the personal property, which is the stuff, causes as much, if not more problems than the financial assets. The way I explain that is I have 3 children, Michael, Maggie, and Matt. And I met in 1972 Mickey Mantle, and I have 2 signed base pictures, rather, of Mickey Mantle. And I want Mickey Mantles to go to Michael and Matt. Maggie wouldn't know Mickey Mantle from Mickey Mouse. So I want the boys to get the Mickey Mantles. And if I have and I do have a contemporary will or trust, if you today have a contemporary will or a contemporary trust, it will include language that says, I may pass certain personal property according to a list I have created. The estate planning attorney will give you that list. So on my list, it says, Michael and Matt get Mickey Mantles. If I don't have that list, and my son-in-law, who's a sports nut, shows up at the party when I die and says, I want a Mickey Mantle too, then I have 3 people after 2 Mickey Mantles. What happens then? Mickey Mantles have to be sold, and then the cash gets distributed. That's not what I want. You see how that is part of communication. We work with a woman who has this large China doll collection, and she has a trust, and First Community Trust is a successor trustee. And it's interesting because she says, I have this huge doll collection, and I have 3 daughters, and my daughters are going to fight like cats when something happens to me. And so this woman's trust says when she dies, the successor trustee, which is First Community Trust, we're supposed to go buy a game of Monopoly and separate the money into 3 equal piles and have an auction for the dolls. And everyone says, that's kind of cute, and you see how that can reduce stress? But the real brilliance of what this woman and her attorney has done is it puts all 3 daughters on an equal playing field. They all have the same amount of money, if you will, to purchase the items. If she didn't have that clause, and if one daughter had significantly more money, that one daughter could buy significantly more of the collection. So this is just another way, and hopefully you see how that starts to minimize stress and conflict. With a will, you get to name a beneficiary, you name your executor. We'll talk on the next slide about probate and what that is and the cost associated with it. For people that are younger with minor children, I believe it makes a tremendous amount of sense for you to have a will, if for no other reason than to say, should something, God forbid, happen to both parents, who is going to raise the children? Who do I want to raise my children? I don't think you want families fighting over who's raising children. If you have a will, you can give to charity. We'll talk about making specific distributions, reducing estate taxes, and we'll also talk about establishing a trust that continues after you die. As I mentioned, if you have a will, you'll go through the probate process. Even if you don't have a will, the state in which you reside is going to have a formula which disposes of your assets. By having a will that you have created with an attorney, I think you can do a much better job of saying how you're going to dispose of your assets. So whether you have a will or you don't have a will, you have to go through the process called probate. Probate's one of those misunderstood words. People hear it a lot, but they don't know exactly what it is. Probate comes from the Latin word meaning to prove. Probate has nothing to do with taxes. Probate is the court-supervised process of settling a person's estate. Let's say I die and First Community Trust is my executor. When I die, First Community Trust will go down to the courthouse and say to a judge, Your Honor, we are the executor of Chip Murray's last will and testament. The judge will review the document. If everything is in order, if it's witnessed properly, it will say, okay, First Community Trust, I hereby appoint you executor. It is then the executor's job to prove to the court that everything in my last will and testament is taken care of according to my wishes. So the executor is appointed. In the probate process, the executor also hires an attorney to assist with the process. And it's important to recognize in this setting, the attorney is hired by and works for the executor. And then it's the executor's job to gather assets and records. And then that, if people ever see a little notice in the newspaper after someone passes away, that's really an important piece of paper. If a person has a will or if a person has a trust, that notice has to be published. And what that says is if the deceased owes anybody any money, a creditor has 4 months to come forward and make a claim against the person's estate. It's one of the real beauties of the process, in as much as after 4 months, no one can come and make a claim against a person's estate. So that notice is important. During that 4-month period, then generally an inventory and an appraisal of all the assets are made. If there are any claims made, they have to be paid. Generally speaking, a couple tax returns have to be done. And then the estate is ready to be closed. And the executor will go back to the court and say, Your Honor, we have proved to you, with all the associated documents we file, that we have done everything in Chip Murray's last will and testament. The judge will review everything, everything's in order, he'll agree and say the estate is closed, and then the assets can be distributed to the beneficiaries. Generally speaking, the estate process, the probate process with an estate takes about 12 months. It can be a little shorter, not too much. It can be longer if there's a lot of conflict. But generally speaking, the probate process takes about a year. Probate is a word that has a bad reputation in as much as people, and you may have heard people say, I want to avoid the cost of probate. There is a cost associated with probate. In most of the states in which we work, the cost of probate is up to 4% of a person's gross estate. 2% goes to the executor, 2% goes to the attorney. So let's say when I pass away, I have an estate worth $500,000. The cost of probate is $20,000. And people say, wow, that's a lot of money. And yes, that is a lot of money. And I don't dispute the fact that $20,000 is a lot of money. But I think it's also important for people to understand, and those of you who have been an executor probably do understand, there's a lot of work associated with probate. After my dad died, we found in his basement a box with 14 life insurance policies. My dad had named First Community Trust as his executor for reasons I'll talk about a little bit later, but it was the executor's job to call and find out if those 14 life insurance policies had any value. Someone had to call each of those companies, which on the face of it, people say that can't be that big a deal. My dad died in his 80s. He bought the policies in his 40s. Do you know how many times insurance companies have been bought and sold and merged? And you get into 800 heaven trying to find the right person to talk to. And I can guarantee you that no two companies ever require the same forms. It was an enormous amount of work. And after all of that was said and done, we had found out that two policies had $5,000 in value. But that's the job of the executor, to do those sorts of things. I also can tease my father because he's not here to get mad at me. But when my dad was alive, I think he fashioned himself to be Warren Buffett when it came to investing. When he died, we determined he was more like Jimmy Buffett when it came to investing. He had assets everywhere. He'd chase CD rates to Arizona for an extra 1/8%, then forget that it was there. He had Treasury Direct, Treasury Indirect, every way you could buy Treasury, he had it. And it's the executor's job then to get everything identified, retitled, so there is a significant amount of work associated with the probate process. And the last thing, before I get off the cost of probate and I get off of probate and talk about how people want to avoid it, the other thing, when people think about the cost of probate and everything that's involved and what the executor has to do, I always suggest to people, when you go home tonight, take 2 steps inside your house and look around and say to yourself, who's going to sell this? Who's going to clean this? Who's going to appraise this? Who's going to take care of all of that? And that's the job of the executor. So I don't want people to walk away from this session thinking probate is not a good thing or the cost associated with probate is not many times earned. However, having said that, many people say, I want to avoid the cost of probate. This is what they're talking about. And the way people can avoid the cost of probate is during their lifetime, establish a revocable or living trust. Revocable trust, living trust, they both mean the same thing. I'll call it a revocable trust, I'll call it a living trust, I'll call it a revocable living trust. It all comes back to a trust that you establish during your lifetime to cover 3 periods of your life. The first period is when you're alive and well. The second period would be if you were to become incapacitated. And the third period would be what happens at your death. If you have a living trust and if you get all of your assets titled properly, that is how you avoid probate. The picture on this slide, I think, makes it a little easier to understand. Think of a living trust as a big box. We want to get all of our assets into the box. And so the person that starts the trust is considered a grantor. So let's say I have $500,000 in my money market account at Dupaco, just in my name. My wife is predeceased. I want to avoid the cost of probate. I will go back to my estate planning attorney, and he will draft the Chip Murray Revocable Trust dated March 31st, 2017 Chip Murray trustee. Chip Murray will be the grantor starting the trust. I will be the trustee in charge of my trust while I am capable. My trust will also include language that will say who is my successor trustee, who takes care of my affairs if I become incapacitated or when I die. When I die, that successor trustee starts to look a lot like an executor. And also my living trust will have in it, and this is important, all of those same dispositive provisions that my will did. Remember, my will had those dispositive provisions that said, when something happens to me, this is where my money goes. Now my trust has that same language in it. Because of that, a person will either have a will or they will have a trust. They won't have both because the trust now has that language in it. So I have my $500,000 in my checking account at Dupaco, and I want to transfer my checking account into my trust so I can avoid probate. I'll come back to Dupaco and I'll sit down, and my account will be retitled into the Chip Murray Revocable Trust dated March 31st, 2017 checking account Chip Murray trustee. My checks will still say Chip Murray. Chip Murray will still sign his checks. My Social Security number is the same for my trust as it was before. The only thing I have done is made a transfer during my lifetime into my trust. And because I made that transfer at the time of my death, I avoid probate. That is how people avoid probate. If I have a house, I need to retitle that into the name of the trust. It costs about $45. If I have stocks, if I have bonds, the goal is, in order to avoid probate, you have to get all of the assets into the box, into the trust. Many times people come back in the spring of the year and they've wintered in Texas or Florida or Arizona, and they will say, we went to an estate planning seminar, and for $99.99 we now have a living trust. And more often than not, for $99.99, they have 14 pieces of paper stapled together. because no one helped them transfer the assets into the box. And many times people that have these done out of state will be governed by the laws of the state in which they were drawn up. Again, I come back to the idea, we work hard to make our money. What we're doing is putting a plan in place to communicate to those we care about the most. I think we want to work with a good local estate planning attorney to make sure the plan we have is right for us. And so if I get everything in the box, that's how I avoid probate. And then at the time of my death, my trust acts just like my will would have acted. But by having all the assets in the box, that's how I avoid probate. It's important, and I keep beating that topic to death a little bit, you need to get all of your assets transferred into the name of your trust. And if you're working with a good attorney, if you're working with someone like First Community, we make sure that happens. As I've indicated, your trust is written with you as the grantor, you as the person that's starting the trust, you as the trustee, meaning you're in charge of your trust while you're capable. And it also says on this slide, you're the primary beneficiary. If you think about it, when it was my checking account, it was my money. I was the beneficiary. Nothing has changed by putting the assets in the trust. And then you will also name your successor trustee, as I mentioned, and then your beneficiary. There are many reasons just beyond avoiding probate that people consider having a trust. The next bullet on this slide talks about the fact that a trust is more private than a will. I talked about earlier that probate is a court-supervised process of handling a person's estate. People could go down to the courthouse and find out what the decedent has, who gets the money, and so forth. I don't know anyone who makes great sport of doing that, but it is public record. A trust is much, much more private than a will. And that's a reason sometimes people like to have a trust. Now, the last bullet on this slide makes a little bit of a fibber out of me, in as much as I said earlier, you're going to have a will or you're going to have a trust, right? If you have a trust, the estate planning attorney you're working with will prepare a one-page document, and it is called a pour-over will. All this one-page document is going to say is, if I forgot to put anything in my trust, put it in my trust. You think of that, see that pour-over, it's called a pour-over will because it's pouring everything in the trust, because the trust has all the language as to where the money goes. Important to remember, if the pour-over will has to be used because you forgot to put something in the trust, what else has to happen? You have to go through probate in order to have that become effective. So again, it comes back to the idea, getting all of the assets into the trust is really important. The other thing before I get away from the revocable trust is the thought that is the need for me to have you understand that a revocable trust does not take away any of your control. Sometimes people hear the word trust and I think they believe they have to give up control. With a revocable trust, you have given up absolutely no control. You can amend it at any time. You can revoke it if you want at any time. And I think that's important to remember. The other another benefit of having a revocable trust deals with powers of a power of attorney. If someone has a power of attorney, they have the ability to completely handle the financial affairs of the person who gave them that power of attorney. When I get to the end of the session today, you will see that one of the components of a complete estate plan would be having a power of attorney. I caution people to be careful who you give that power to. We were working with a woman locally whose husband had predeceased her, and she had two children. She had a daughter locally, and she had a son in St. Louis. And this woman was having significant health issues, and she was going in for surgery, and so she made both her son and daughter co-powers of attorney. I will address a little bit later also, co-anything becomes a little bit problematic at times. If with co-powers of attorney, that meant that the son and the daughter had to sign every document because they were co-powers of attorney. Since the son lived in St. Louis, it wasn't working very well, as you might imagine. So Mom said, my daughter's here, I'll just make her power of attorney. Makes a lot of sense. The daughter takes her, so now the daughter's power of attorney, she takes her power of attorney papers to all the financial institutions, said, I have Mom's power of attorney. Good job, right? She also made every single account her mother had joint with right of survivorship, which she could because the power of attorney gave her that power. Mom died, who got the money? She did. Who's not happy? The son. Mom's will said divide everything 50-50, and I truly believe that that's what the woman's intent was. However, the daughter, it's in court, and the daughter is saying, Mom told me to do that because I was taking care of her, and she wanted me to have the money instead. So I wouldn't really want to be the judge there. Nonetheless, if someone has my power of attorney and I get in an accident today and I can't handle my financial affairs, the power of attorney would step in and handle my financial affairs. If I were to die, the power of attorney ceases. Power of attorney ceases at death. What picks up after death? The executor. So you think power of attorney before death, executor after death. If I have a trust and that First Community Trust is my successor trustee, and I get in an accident, First Community Trust could take over as my successor trustees to handle my financial affairs. In addition, if I were to die, First Community Trust continues to be my successor trustee because I don't go through the probate process. And because of that, settling a trust can sometimes be 3 months quicker than settling an estate. And I think in many cases that is also a very positive benefit of having a trust. Before I get off of power of attorney, it's important also that I suggest that if you have a power of attorney or you have a successor trustee, I would encourage you to work with your estate planning attorney to have language included that says, my power of attorney or my successor trustee becomes effective if I am incapacitated, and this is the important point, as attested to by my physician. Many times in the olden days, the language just said, if I am incapacitated, the successor trustee takes over. We had a case where a gentleman had that language that said if he was incapacitated, First Community Trust became successor trustee. The man was in an accident. 2 of his kids said Dad's fine. 2 of his kids said Dad's not fine. We ended up in court to have a judge determine if Dad was fine or not. If you have the language as incapacitated attested to by my physician in the document, then the physician could testify or could verify that Mom or Dad or whoever is unable to handle their financial affairs. It protects both the power of attorney and it also protects the person giving that power of attorney. Just something to keep in mind. And so as we move forward, I'm going to switch streams just a little bit. Up until this point, we've been talking about wills. Everybody with me, I hope. If you have a will, you have an executor, you have the dispositive provisions, and then you go through probate. If you have a trust, you have the successor trustee, you have the dispositive provisions, and you can avoid probate. So you can see how they're kind of first cousins. What I've talked about up to this point are trusts that you have during your lifetime, a revocable trust or a living trust. There are many reasons people may wish to have a trust that continues after they pass away. If I have a living trust or revocable trust during my lifetime and I die and I want the trust to continue after I have died, it is then called an irrevocable trust. After I die, it cannot be changed. If I have a will and in my will it says, after I die, I want a trust to continue, it is called a testamentary trust. Think of last will and testament. An irrevocable trust and a testamentary trust cannot be changed. But in our opinion, we think these types of trusts can really make the lives of those you care about the very most a lot better going forward. There's a lot of reasons to have a trust. Probably one of the biggest today is that if people have multiple beneficiaries, say multiple children, they don't want all of the money perhaps to go to their beneficiaries all at once. We have, and it's a reasonably new account that we dealt with, that this gentleman had 3 children, And one of the children, he believed probably could use financial assistance for a longer period of time. And he put a plan in place to take care of that child for the entire lifetime of the individual. I think that's neat. That's kind of what we're talking about. I have 3 children. You know, I may or may not think that they all can handle financial affairs as well as the other. You have the option, and that's what's important when we're talking about an estate planning plan, is when you're working with the attorney, there is absolutely no reason that you shouldn't be able to get in your document what you want to address your specific needs. And generally, it's that first one. I've seen people give money at 25, 30, 35, 30, 40, 50. Every case is different. But again, what you're doing is trying to make the lives of people better for a longer period of time. The second bullet on this page, or on this slide, talks about second marriages a little bit, and that today with second marriages, when the first spouse passes away, many times the spouse that passes away wants to provide for the surviving spouse. So they can have an irrevocable trust set up that provides for the surviving spouse. Perhaps the surviving spouse can get all of the income off of that trust, and when the surviving spouse passes away, then the principal would go to the biological children of the first spouse. The reason that's important is, I think, again, we're talking about having something in place that avoids conflict. We have people that come in, and just a couple weeks ago, a couple came in, they each had 2 children, and it was a second marriage, and they said, we love each other's children dearly. And I have absolutely no doubt that they love each other's children dearly. And they currently have wills that are traditional. When the first spouse dies, everything goes to the surviving spouse. Important to note, what can the surviving spouse always do? And the answer is change it. You know, and so in order to avoid conflict, if it's a second marriage, it may be worthwhile considering each spouse having a revocable trust that would address any issues that may exist, and again, after the first spouse passes away, dramatically decrease the chances for someone having an issue. This particular slide, I think, is a reason people may want to consider having a trust that survives their lifetime, or an irrevocable trust during their lifetime. If a person is single or widowed during their lifetime, I think it makes sense for them to have revocable trust for several reasons. The person I talk about here a lot is my mother. After we got everything settled with my dad, all of the assets were transferred to my mom. My mom said, I don't want to handle any of this. And so she established the Doris Murray Revocable Trust. Doris Murray is trustee. My mom is 94 years old. She's her trustee of her revocable trust because I cannot find a doctor that says she's incapacitated and cannot handle her financial affairs, even though she bought 3 Kirby vacuum cleaners in a single night a couple of years ago. Nonetheless, my mom is her own trustee. All of the assets are in her trust. When my mom passes away, all of the assets will pass to the beneficiaries without probate. It's kind of textbook. I contrast that with a woman we worked with in Cedar Rapids, actually, and this particular woman had amassed quite a bit of money. She divorced early. She had 1 son. She inherited a farm. Altogether, this particular woman had about $2 million in assets, and she trusted absolutely nobody. And we got involved because the woman was starting to lose her mental faculties. And so we found a judge and we found an attorney, and we were able to create what is called a voluntary conservatorship. It's a court-supervised account. The court said, First Community, you manage this woman's money, you pay her bills, but every year we had to report to the court what we were doing. About 18 months later, the woman passed away, and $2 million had to go through probate. Just the cost of setting up that conservatorship was $12,000. People that are single or widowed, having a trust in place accomplishes a lot. And I always say, when we're talking about estate planning, and I think about my mom to the extent that today she could not probably puts the best plan in place for her. Today, we have the ability to put a plan in place for us today. We have the ability to amend it if things in our lives change. But by having a plan in place, it protects us not only today, but I think to an extent it can protect us from ourselves at some point in the far distant future where we may not be able to take care of ourselves. Other reasons that people consider a trust is if they have a disabled relative. If you have a disabled relative that is requiring state or federal aid, having what is called a special needs trust may make sense because it provides for that particular beneficiary while at the same time not having them become disqualified from any state or federal aid. Those are the sorts of things that we can visit with people about if that's appropriate for their particular circumstance. And the last bullet when we're talking about trust, if people own real estate in more than one state, they should have a trust if for no other reason than to put the real estate from the other state into the trust. What we're trying to do in this case is to avoid probate in two states. You do not want to go through probate in two states. So if people own property in more than one state, please visit with us because you really should have a revocable trust. First Community Trust helps a lot of people. We make these sessions educational, and I think you'll hopefully find it so up till this point and going forward as well. But we'd like to take just a second to say we enjoy helping people. We are very good at helping people who don't have the time, who don't have the ability, who don't have the desire to handle their own financial situation. And we think we can do a very good job in helping people with their money as well as with their estate planning. We have several different approaches. Most of the people that we have worked with have found that one of our approaches works very well for them. And so if you would fall in any of those categories and would like to visit again, we'd very much like to visit with you. A few more things as we kind of hurtle towards the finish here. We want to take a few moments to talk about federal estate taxes. First of all, you see the bullet up here that says annual gifts. Annual gifts today, I could give everybody that's hearing my voice, I'm not going to, but I could give everyone that's hearing my voice $14,000. A couple could give $28,000. Annual gifts become important, I think, as people get later as they age and have more money than they probably are going to need for themselves. And we see people start gifting to their children or grandchildren. People can give $14,000, a couple can give $28,000 and not have to file any additional tax return forms. The most important number on this particular slide is the one titled Unified Credit. The Unified Credit deals with federal estate tax and Iowa inheritance tax for that reason. Today, everyone in the United States has a unified credit worth $5.49 million. I want everybody to think that you are holding a gold token that is worth $5.49 million. If I die today with $5.49 million or less and give my money to my children and to my grandchildren, I pay no federal estate tax, I pay no Iowa inheritance tax. Essentially, death taxes as they were known in the past no longer exist. A couple can protect up to $10.98 million. There was a lot of discussion about this at the national level in 2013, and Congress passed a law that made this unified credit permanent. And essentially what they did was eliminate federal estate taxes for the vast majority of Americans. And it's a permanent law that is indexed every year for inflation. So where many times in the past people worried about having to pay estate taxes at their death, today it is very much less an issue for the vast majority of Americans. This particular slide I put in just for fun. It talks about famous people, and I think everybody likes famous people. And the red part of each of these pies represent how much of the person's estate was eaten up in estate taxes and also attorney fees. So FDR is up on top. FDR, 30% of his estate went to attorney fees and estate taxes. Stan Worrell, only 8%. If you go out to Hollywood, Marilyn Monroe and Elvis died without a will. And Marilyn Monroe's estate, more than half, 55% went to attorney fees and estate taxes. Elvis, 73%. Michael Jackson died a few years ago, and a few seminars ago I said Michael Jordan died a few years ago. Michael Jordan's fine. It was Michael Jackson that died. Michael Jackson, I was not a huge fan of his music, but Michael Jackson had outstanding estate planning. He had a good attorney, good accountant, good trust officer. He said, who's going to take care of his kids? He has trust set up. He did everything he could possibly do well, done well. Now, due to the sheer enormity of his estate, I'm sure they'll be fighting about it for many, many years. I contrast Michael Jackson's estate with Prince's estate. If you want to read a real mess, Google Prince estate. He died without a will. That will be going on for years and years and years, and the attorneys in those situations are going, and his situation is going to do quite well. I said earlier that I asked people to do two things as a result of being here today. The first one was to check your beneficiaries, check how your accounts are titled. The second one is if you have a will or if you have a trust, check and see who have you named as your executor, who have you named as your successor trustee. I think it's a very, very important decision a person makes who is going to handle the affairs after you're not here. And I think you have to ask yourself and maybe ask the person you're thinking about, do they have the ability, do they have the interest, and in today's society, the most valuable commodity is, do they have the time to do it? The other thing I think you have to keep in mind is, whoever you name as executor, you're kind of putting a bullseye perhaps on that person's back. I have a good friend that I ran into at a football game a few years ago, and I said, George, you look terrible. He said, oh, my dad died this year. I said, I'm sorry, I knew you were real close to your dad. He said, it's not that. He said, my brothers don't talk to me anymore. I said before, my dad had originally named me as his executor, but I wanted him to name the company because I did not want to deal with one of my siblings at the time of his death. We still get along. I just did not want that emotional stress. I always say to people, if you have multiple children, do you really love one that much that you're putting them in the middle of all of that with a bullseye on their back? There is no right or wrong answer. I think a lot of times in the past, people have named a family member to save 2%. Remember, 2% goes to the executor, 2% goes to the attorney. I also have gotten a little bolder and suggest if you have a family member do it, and they have to go through all the work, and they have to go through the emotional distress of being an executor, aren't they entitled to something? I want everyone to understand, I am not attempting to suggest First Community Trust should be your executor or successor trustee, although in almost every state, at least one executor has to be from the state of residence of the deceased. So many times we become a co-executor in those situations. We have a lot of experience in that regard. We have done it a lot, but I've seen many families use family members that work fine. There's not a right answer. There's not a wrong answer. I just really believe there should be a well thought out answer for your family. To conclude, I like to talk about the components of a complete estate plan. If you have a complete estate plan, you're going to be having these components, these documents as part of your estate plan. If you have a will, you will have a will or a trust for each person. If you have a trust, you're going to have that pour over will. Remember that one-page piece of paper that said to pour it into the trust? You will also have a document that's called Declaration of Designee for Final Disposition. In addition, I talked about the durable power of attorney. You'll have to be careful who you give that to. But the Declaration of Designee for Final Disposition is the person who is in charge of determining who's going to essentially handling the funeral arrangements. Where should the funeral be? Where should the person be buried, etc. That too is kind of an outgrowth of second marriages. And then the estate planning attorney will also prepare the living will and the healthcare power of attorney. That's the components of the complete estate plan. My dad died in 2004, 13 years ago. 5 years before he passed away, he had to go through open heart surgery up at the University of Wisconsin in Madison. And a few nights before his surgery, he took me down into the family room that we had. And the first thing he did is he handed me a manila envelope with duct tape on two sides. And he said to me, in this envelope are all of my financial assets. If anything happens to me, you can look in there. He said, if nothing happens to me, I'll know if you looked in there. And I said, I know, you needed a blowtorch to get into the thing. When my dad died 5 years later, as you might imagine, the envelope was open, but his records were horribly inadequate. Going back towards the beginning of the seminar, when I say, if you have a listing of all of the assets in your estate and keep it current, it really, really, really makes a difference at the time of a person's death. There's also a sheet that we have available called 18 items you should record for loved ones. And that is something also that if you fill that out, it makes the lives of those you care about the most much easier at a very difficult time. The second thing my dad said to me that night, we were in the lower family room, he said, you're my healthcare power of attorney. And I thought, this is going to be the shortest conversation I've ever had with the man. I said, you don't want to be hooked up to machines. You don't want heroic measures. You don't want. He's nodding his head. No, he said, I don't want it. He said, I don't want it. He said, I don't want any of it, he said, unless there's a chance. And I go, oh. And that prompted a discussion between my father and myself, probably one of the better discussions that I had with him as an adult. It gets back to communication. It's another part of that whole communication process. That's what we're trying to attempt with estate planning. Hopefully that's what I've conveyed a little bit, that having a plan in place, having a plan that you can communicate your wishes is important. I'm not naive enough to think that there's going to be a family holiday and they're going to say, sit down, pass the mashed potatoes, do you want to hear about my estate plan? Those sorts of things generally don't happen. My family could have never done anything like it. Occasionally families can talk about it, and that's kind of neat. However, we do, if you're listening to this or seeing this, you do have an ability to put a plan in place that's going to make the lives of those you care about better at some point in time. There are all sorts of different ways of doing it. If you cannot talk about it, having a well-established, well-written will and trust is important. Another way, I had a very good friend that died 10 years ago now, and he had cancer. And before he got sick with the cancer, we had largely put his estate plan in place. After he got sick, we kind of fine-tuned it, and he had some significant assets. He did not want his children to know about the financial details of what was going on. And so what he did is he had his trust that was quite good, but in addition to that, he had done something that I knew about. And 3 days after he passed away, I was in his attorney's office with his 3 kids, and he had written them a letter. And the letter said, my dear children, I'm writing this letter to you with the intent that you will only be reading it after I've died. I wanted to discuss the contents of this letter with you during life, but I thought it best not to talk about money when our personal relations mean so much more to me. However, I did want you to know my intent as it relates to the money that you will be receiving upon my death. I can't resist the opportunity to give you my thoughts on the use of the money you receive. It is my hope and prayer that you will set aside a portion of the money for the education of your children. Education is the cornerstone of any good career. Please see that your kids get a good education. I'm only sorry that I won't be present in person for each graduation, but rest assured I'll be there in spirit. With the balance of the money, if you choose not to save it at all, I hope you're able to pay a few bills, buy something you need, or just take a vacation and remember your dad. All that you inherit comes to you free of any restrictions or obligation. I can only rely on your good judgment and your willingness to listen to your dad one last time on what to do with this money. I wish the best to each of you. I love you all dearly, Dad. It was a very powerful, remarkable moment. He's right in here where he says, all that you inherit comes to you free of any restrictions or obligations. This letter could not do that. That would have to be in the will or the trust. But there is no doubt what his intention was for his children. He conveyed the message. It was another form of communication. I challenge people, you know your family is the best. How do you best want to communicate your intention? First Community Trust really enjoys assisting people, whether it's estate planning, retirement planning, helping them invest their money. If as a result of today you have questions, or if as a result of today you want to sit down and discuss your personal situation, our trust officers at DUPACO would be most willing to sit down and be with you. We appreciate the opportunity to visit with all of the DUPACO members, so at any time it might be appropriate, don't hesitate to give us a call.
If you do have any questions, though, please feel free to contact First Community Trust. I have some contact information up there. Also go to the DUPACO website, dupaco.com, and you will find more information about them as well. So thank you, everyone, for joining us today. I hope you found it informational, and have a great day. Thank you.